So let me begin with the standard disclaimer. I speak for myself and not for anyone else at the FTC. Of course, I think everyone understands that by now. So I want to start, as Aaron did, with a story. And my story gives a little bit of context on why I feel the way I do about rules. So in private practice, I represented a low-cost, low-price retailer that wanted to expand into California. But the rivals of this retailer knew from experience in other states that they would lose customers and market share to the new entrant. And so they launched a campaign to keep my client out. City by city, town by town, they manipulated state and local laws, rules, and regulations to their advantage. They delayed my client's entry and raised my client's costs, beneficial to these less efficient rivals, but detrimental to consumers. And during the course of that representation for that client, I came across a book by Professor Schell at Wharton that was fittingly titled, "Make the Rules or Your Rivals Will." Professor Schell asserts that, quote, "For every simple, neutral law that we pass, there are 10 designed to tilt the playing field. In other words, laws and legal institutions can make or break a business or an entire industry," close quote. He also observes, quote, "Laws not only define markets, they set the rules of competition within them. By leaving law and legal maneuvering to your rivals, you place the fate of your business in their hands," close quote. So in other words, the rulemaking process creates a rich environment for maneuvering to gain a competitive advantage. And this is one reason why I maintain a deep skepticism about the supposed benefits of most rules. In other words, they're not necessarily so much about fostering competition and innovation as fostering rent-seeking. So you can imagine my reaction when the Biden FTC unveiled its plans for an ambitious rulemaking agenda in December 2021 and began implementing that agenda in 2022. My team and I have labeled this rulemaking extravaganza the Rulapalooza. I know, it doesn't have quite the same ring as Commissioner Phillips' phrase, zombie votes. But to me, the avalanche of rulemakings is scarier than the zombie apocalypse. It carries grave consequences for consumers, competition, the FTC, and the U.S. economy. So during my brief time with you today, I'd like to explain the dangers of unchecked FTC rulemaking. First, I will outline the negative impacts of rulemaking. Second, I will discuss the agency's competition rulemaking efforts and the shaky legal footing for any substantive competition rules. And third, and perhaps the most intimidating, because Howard Beals is sitting in the audience and taught me everything I know about consumer protection and FTC rulemaking, I will discuss developments in the consumer protection mission, including changes to the agency's rules of practice that undermine congressional intent by fast-tracking consumer protection rules. Howard, I think I even quote you, and Tim. So let me start with the first topic, the cost of rules. Throughout my tenure at the Commission, I have expressed concern about the negative impacts of rulemaking. I've already given you one rationale, the likelihood of rent-seeking, but there are more. First, historical experience teaches that rules stifle innovation, increase costs, raise prices, limit choice, and decrease output. They frequently harm the very parties they are intended to benefit. Prime examples include the disastrous regulatory frameworks in the transportation industry, the Civil Aeronautics Board, and the Interstate Commerce Commission. Second, competition rulemaking will freeze the legal and economic analysis of any conduct subject to a rule. In other words, the perennial refinement of legal and economic analysis grinds to a halt. Third, a rules-based approach is incompatible with the effects-based and fact-specific analysis we use today. Why throw out several decades of learning? Fourth, rulemakings rely on a one-time snapshot of industry dynamics, but in the real world, business practices change quickly. The rulemaking process can't possibly adapt as quickly to changes in market dynamics because it's lengthy and cumbersome. For example, simple amendments to the FTC's contact lens rule took more than 5 years to complete. Why? Because various industries were at war with each other using the rule as a rent-seeking opportunity. Fifth, regulations risk inhibiting innovation. The FTC's care labeling rule specifies which care instructions can be placed on garment labels, but the FTC doesn't acknowledge the existence of emerging rivals to dry cleaners known as wet cleaners. Thus, manufacturers can't put the technology on their labels, and so consumers don't know about and can't demand clothes with this form of cleaning technology. Sixth, particularly on the consumer protection side of the house, I am concerned that there are existing or emerging threats to consumers we aren't pursuing because resources are so focused on rules instead of cases. Seventh, as I highlighted in my introduction, each rulemaking encourages companies to shift resources from competition and innovation to rent-seeking and regulatory gamesmanship. So far, I've identified potential harms to consumers, competition, innovation, and the economy, but my final aversion to FTC rulemaking, particularly on the competition side, is that we will repeat the mistakes of the past and incur the wrath of Congress. More on this momentarily. So, with that background in mind, let's talk about competition rulemaking. 7 weeks ago, the FTC issued a notice of proposed rulemaking regarding non-compete clauses. The proposed rule would declare non-competes an unfair method of competition and ban their use, with an exception for non-competes associated with the sale of a business. Before discussing the problems with this NPRM, let's take a step back. Understand that the Commission needed to find a hook for the FTC to ban non-compete provisions. Congress didn't pass a new law banning non-competes and then direct the FTC to design implementing rules, which it frequently does on the consumer protection side of the House. The antitrust statutes themselves don't provide a basis to prohibit non-compete clauses. State and district courts have repeatedly held that when non-compete agreements are reasonable, they don't violate the antitrust laws. And the Seventh Circuit held that unless non-compete clauses are unreasonable, they are legal under Section 5 of the FTC Act. So what is an ambitious commission to do? Enter stage left, the Section 5 policy statement regarding enforcement of unfair methods of competition issued just 2 months before the NPRM. As you may know, Section 5 of the FTC Act contains 2 separate prohibitions, one on unfair methods of competition and the other on unfair and deceptive acts or practices, known as UDAP. The Section 5 policy statement set out a new approach for invoking the unfair methods of competition provision. Specifically, the policy statement provides that a violation of Section 5 occurs when a company engages in, 1, a method of competition, that 2, is unfair. And there are 2 criteria to consider when analyzing whether unfairness exists. First, conduct may be unfair when it is coercive, exploitive, collusive, abusive, predatory, deceptive, and so on. Second, the conduct must tend to negatively affect competition conditions by affecting consumers, workers, or other market participants. Now, when the conduct is labeled facially unfair, pursuant to the first criterion, the second criterion is rendered essentially irrelevant, as the subsequent cases have demonstrated. Thus, conduct may be considered unfair based only on the assignment of nefarious-sounding adjectives, such as coercive or exploitive. I dissented from the Section 5 policy statement for several reasons. It abandons long-accepted principles of antitrust. It fails to provide clear guidance to businesses regarding what conduct is and is not lawful. And as the policy statement itself acknowledges, the approach may lead to conclusions, that is, finding violations of the law that are inconsistent with precedent under the antitrust laws. And I'm sure that when Elizabeth speaks later today, she's going to talk about how Section 5 is intended to be broader than the antitrust laws. And that is true. That is true. So with that knowledge under our belts, let's return to the proposed NPRM. So as it turns out, non-compete clauses are one of those areas where the new Section 5 policy statement leads to conclusions that are inconsistent with precedent. The NPRM states that there are 3 independent bases for classifying non-compete clauses as an unfair method of competition. 2 of the 3 explanations rely only on invocation of the adjectives exploitive and coercive. The NPRM explains that except for senior executives, first, quote, non-compete clauses are exploitive and coercive at the time of contracting, close quote, because they take advantage of unequal bargaining power. And second, quote, non-compete clauses are exploitive and coercive at the time of the worker's potential departure from the employer, close quote. The third basis for classifying non-compete clauses as unfair depends on the NPRM's conclusion that non-compete clauses negatively affect competitive conditions. The NPRM relies primarily on empirical economic literature to support this assertion, but the cited literature actually provides mixed results. The NPRM also cites 3 consents announced the day before the NPRM was issued, but the allegations in the complaints do not provide evidence of market-wide effects for either the products or services of the companies or the wages of employees. For example, a case involving a security guard alleged that individual former employees were limited in their ability to work for other firms in the security guard industry. But the complaint contains no allegations that a firm's non-compete provisions had market effects on wages or effects in a market for security guard services. In fact, the cases don't even identify relevant markets. And 2 of the cases have complaints that total only 3 pages each, including boilerplate. Thin gruel indeed. I know that non-competes may be overused and even abused, but a sweeping ban on essentially all non-competes is bad policy. And I also question the Commission's legal authority to undertake competition rulemaking. Here's where it gets really dry. The Commission proposes the NPRM pursuant to Sections 5 and 6G of the FTC Act. Section 6G authorizes the Commission to make rules and regulations for the purpose of carrying out the provisions of the subchapter, where the rest of Section 6G provides that the Commission may from time to time classify corporations. Now, this provision was long viewed as providing authority for the Commission to adopt only procedural rules. And in fact, for decades, FTC leadership testified before Congress that the Commission lacked substantive competition rulemaking authority. Ignoring this history, the Commission embarked on a substantive rulemaking binge in the 1960s and 70s. One notable example was grounded in both competition and consumer protection principles and prompted a challenge in federal court. The D.C. Circuit in 1973 held in National Petroleum Refiners, in an opinion that never would have been written today, that the FTC did have the power to promulgate substantive rules. Now, Aaron promised us a walk through history, and I think you're going to probably hear a lot about that case throughout the day. 2 years after that case, Congress enacted the Magnuson-Moss Act, which required substantive consumer protection rules to be promulgated with heightened procedural safeguards under a new Section 18 of the FTC Act. Notably, the Magnuson-Moss Act expressly excluded rulemaking for unfair methods of competition from Section 18. It was not clear whether Congress and Magnuson-Moss sought to clarify existing rulemaking authority or to grant substantive rulemaking authority to the FTC for the first time. Given this ambiguity, I believe the non-compete clause rule is likely going to be challenged under the major questions doctrine, which the Supreme Court recently applied in West Virginia v. EPA. This doctrine provides that an agency may not create a rule that will impose major social, political, and/or economic consequences unless Congress clearly grants the agency the authority to do so. Using the analysis in Justice Gorsuch's opinion, his concurrence, a judge will almost certainly conclude that the NPRM is a major question. For starters, it will impact roughly 1/5 of U.S. employees. So then the FTC would be required to identify clear congressional authorization to impose the regulation. But that clear authorization is unavailable. As we've discussed, the language in Section 6G is far from clear. The decision by Congress to omit unfair methods of competition rulemaking in the Magnuson-Moss Act, which followed the decision in National Petroleum Refiners, adds further weight to this conclusion. And Congress did not remove the known ambiguity when it enacted the FTC Improvements Act of 1980. The rule may also be challenged under the non-delegation doctrine, which holds that Congress cannot delegate its legislative powers to another branch of government. Do you remember Schechter Poultry from law school? In that case, the Supreme Court approved congressional authorization for the FTC to prohibit unfair methods of competition because it enforced this law in quasi-judicial fashion. But if the Commission pursues rulemaking rather than case-by-case enforcement of unfair methods of competition, it abandons the basis for the Supreme Court's decision in that case. Ultimately, I believe that challenges to a sweeping ban on non-competes will succeed. So let's turn now to Howard's area of expertise, the rules grounded in the FTC's UDAP authority. When Congress passed the Magnuson-Moss Act in 1974, it explicitly empowered the FTC to issue trade regulations for unfair or deceptive acts and practices. But to cabin the agency's discretion, Congress imposed significant procedural obligations on the Commission. Despite those congressional efforts, the agency engaged in a flurry of rulemaking activity that sought to regulate broad swaths of the economy. And as we've discussed, the negative reaction from stakeholders, including Congress, was swift. Backlash from the agency's sweeping regulatory efforts culminated in the Federal Trade Commission Improvements Act of 1980, which imposed even higher hurdles on Section 18 rulemaking efforts. So Howard Beals and Tim Muris wrote a recent paper, which is just incredible and sort of mandatory reading on this topic if you're interested. And they described that the agency's 1970s foray into rulemaking was doomed for many reasons. The proposed rules lacked clear theories of consumer harm, failed to articulate a clear explanation for why practices occurred, lacked evidence about the systemic nature of challenged unfair or deceptive practices, and failed to produce a rulemaking record that could demonstrate the effectiveness of proposed remedies. So other than that, Mrs. Lincoln, how was the play? This torrent of rule proposals signaled to many in the business community, Congress, and the media that the Commission was embarking on a rulemaking campaign based on its own perceptions of what public policy should be rather than on actual consumer harm, is the description that Tim and Howard offer. Now, ironically, this characterization of events 4 decades ago also describes quite accurately the rulemaking efforts of the FTC under Chair Khan. Take, for example, the Commercial Surveillance and Data Security ANPRM. It is sweeping in scope. It covers essentially all data collection practices. It poses nearly 100 questions, many of which imply the agency will consider issues that extend beyond our legal authority. Here's another problem. Section 18 rules must be based on prevalent deceptive or unfair practices. Practices discussed in the Commercial Surveillance ANPRM are presented as clearly deceptive or unfair, even though they extend far beyond practices within the FTC's extensive enforcement expertise. And perhaps most troubling to me, this ANPRM threatens to derail federal legislation on the same topic. And I am a really strong advocate for federal privacy legislation. Not happy that the FTC may have done something to move that off track. But the Commercial Surveillance ANPRM is not alone. There's another recent ANPRM that is also breathtaking in scope. The junk fees ANPRM could launch rules that regulate the way prices are conveyed to consumers across nearly every sector of the economy. To be clear, I agree with ensuring that consumers have access to sufficient information to make informed decisions, and I agree that they shouldn't be charged for products or services they didn't agree to purchase. But the ANPRM extends well beyond these modest goals. The Wall Street Journal observed that the ANPRM could result in a blanket ban on fees and unbundled prices, which would unfortunately make many markets less competitive. And the ANPRM also extends beyond the enforcement experience of the agency. As noted above, Section 18 rules must be based on prevalent deceptive or unfair practices. Drip pricing, which is a significant focus of the junk fees ANPRM, has not been alleged, let alone litigated, in any FTC enforcement matter. Now, in the spirit of full transparency, I have supported a couple of rules proposed in the last year. The Supreme Court's decision in AMG ended the Commission's use of Section 13B to obtain equitable monetary relief. Section 13B was the foundation for the FTC's fraud program, which enjoyed broad bipartisan support. To enable the FTC to get monetary redress for consumers victimized by fraud, I have voted for rules that are narrow in scope, based on extensive FTC enforcement records, and targeted at typically fraudulent activities like government impersonation. Setting aside rules aimed at fraud, though, the recent barrage of rules raises many questions. Can sensational news stories form the foundation of a rulemaking record to outlaw legal practices never challenged in FTC enforcement matters? Can the FTC consider practices and harms outside our jurisdiction to justify rule proposals? Do our rulemaking efforts reflect sound policies, or rather, sound politics? So while you ponder those questions, I'll describe the July 2021 revisions to the FTC's Section 18 rulemaking procedures. The majority says these changes to our rules of practice eliminate extra bureaucratic steps and unnecessary formalities. But in fact, those changes fast-track regulation at the expense of public input, objectivity, and a full evidentiary record. Let me highlight some of those changes and their implications. The revisions to the rules of practice facilitate manipulation of the fact-finding process. An independent hearing process is essential to crafting rules that address actual market failures rather than pet projects of unelected commissioners. But power over the rulemaking process is now consolidated in the office of the chair. The revised rules remove selection of the presiding officer from an independent judge and assign that role to the chair. This sounds like a dry topic, but the independence of the presiding officer matters because that person oversees the rulemaking hearing process, which helps determine the facts on which the commission bases its policy calls. The old process gave the public some assurance that the proceedings would be unbiased and that all points of view would be heard and considered. But the new process allows the chair to handpick the presiding officer, opening the door for a fact-finding process gerrymandered to fit the chair's agenda. The revisions also strip the presiding officer of significant control over the hearing process. Now, the commission sets the agenda for the hearing, chooses which issues will be discussed, and selects which parties will be permitted to testify, conduct cross-examination, and offer rebuttal evidence. With these changes, the commission can control which facts make it into the record, laying the groundwork for rulemakings based on cherry-picked facts that support a predetermined outcome. Additional changes diminish opportunities for public input and hide our expert staff's assessment from review and comment. And believe me, you want to understand what expert staff is saying behind the scenes. Specifically, the revisions abolish a staff report that analyzes the rulemaking record and makes recommendations as to the form of the final rule. The revisions also remove comment periods on the staff report and on the presiding officer's recommendations. These changes ultimately will harm the agency. To build an adequate rulemaking record, the FTC needs to demonstrate to the courts that it has a sound basis for proposed rules. But these changes remove opportunities for the FTC to show its work. And public input on the proposed form of the final rule is valuable, particularly with respect to unintended consequences that might otherwise escape the Commission's consideration. Foregoing this input likely will reduce both the quality of the final rules and the credibility of the agency. So what's the bottom line? The majority's changes to the rules of practice will facilitate more rules, but not better ones. These changes also will leave rules vulnerable to challenges in federal court because the new rules will be formulated pursuant to an agenda-driven process that limits public input and generates a biased evidentiary record. So, where does that leave us? I put together just some takeaways from this discussion last night as I was thinking through the topic. 1, turn to rules sparingly. We know their harms can be significant and may outweigh their benefits. Ideally, we would limit their use to market failures. 2, scrutinize the proponents of a rule. Check for hidden agendas that may benefit rivals, not consumers. 3, acknowledge the immense resources that rulemakings consume, especially under Magnuson-Moss. As the Rulepalooza has rolled on, the FTC's consumer protection enforcement has fallen significantly, even as fraud has increased. 4, operate within the scope of authority granted by Congress. If there are policy changes we want but can't achieve without overreach, like guardrails for consumer privacy or limits on the use of non-competes, ask Congress to legislate. Does Congress sometimes disappoint us? Yes. Does Congress frequently disappoint us? Yes. Does that mean we can take matters into our own hands? No. Number 5, play by the rules Congress has established. Cutting corners in a rulemaking process jeopardizes the quality of the final rule as well as its legal viability. Number 6, act like an independent agency. When the White House talks about junk fees, don't issue a rule of breathtaking scope, hastily cobbled together, completely untethered from FTC enforcement expertise, just to demonstrate the FTC is on the bandwagon. 7, stay within the agency's lane. The commission is supposed to be an expert body. If we're going to make rules, they should be tethered not just to our authority, but to the areas in which we truly have expertise. So thank you so much for listening to Rulemaking at 9 a.m. on a Friday morning. I see some eyeballs that are still propped open. And I think, Aaron, we're going to have some Q&A.
Yes. All right. So here's your chance. Thank you so much for that. That was wonderful. Can see if they can hear me. I'll sit here. If you have questions, if not, I have some questions, but who would like to ask a question of the commissioner? All right, let's just go all the way down this way. So you.
But let me just do one.
Of course.
I want to honor all of the work that Aaron and his colleagues put into putting this event together. It is designed to be focused on FTC rulemaking, and so if folks would focus on FTC rulemaking in their questions, I would greatly appreciate it. That is just a way to honor Aaron and his work.
Thank you. All right, yes.
Hi, Leah Miley from Bloomberg. In your comments, you seem to acknowledge that in some cases, non-competes can be too broad, or that there could be junk fees that are also overly broad. What do you think the FTC should do in those cases?
So, absolutely. There are many non-competes that are unreasonable. We have at least 700 years of court cases dealing with the extent to which rules, non-competes are reasonable in scope, length of time, line of business, et cetera. And so when you've got so much state law and federal law on non-competes, a good start is to look to that law. And so what the NPRM does is essentially overturn the law of 47 states. If you don't like non-competes, several things are possible. Number one, Congress has actually spent a lot of time looking at this issue. Bills have been introduced. Number two, state attorneys general have been attacking this issue, and especially with respect to fast food companies have made significant inroads. Number three, if the FTC wanted to get involved in this area, it could bring cases that provide a full factual explanation of the non-competes and why they are unreasonable. Number four, if we wanted to do a rule, I would have done a rule that looked like the funeral rule or the franchise rule, one that is designed to give disclosure to the potential employees. I think people are capable of making informed decisions for themselves. And so if we had said, a potential employer needs to point to the fine print in a 5-page employment agreement that says, there's a non-compete and here's what it means to you, that would have been good. If there's consideration for that restraint, that would be good. But help people understand what it is that they're signing up for. And that could have been done under UDAP, and the FTC clearly has authority to do that. If we were going to do a competition rule, and I don't think we have authority to do a competition rule, We could have done a narrow one that is emphatically supported by the empirical evidence. Let's look at people employed in jobs where they're paid by the hour. They're clearly not getting, the secret recipe for Coke or, other very high-value IP. So those are some of the alternatives.
All right, Tom?
Hi, Tom Merrill from Columbia. As you pointed out, the FTC engaged in adjudication in competition matters for decades. They shared that authority mostly with they shared the authority with the Justice Department and Antitrust Division, which engages in enforcement of the Sherman Act and the Clayton Act, and so forth, entirely through adjudications in court. Do you have any insight as to what the attitude of the Justice Department's Antitrust Division is to this big push by the FTC to seize for itself antitrust rulemaking authority when the Justice Department has no plausible basis for doing that itself?
So I have no idea what the Justice Department is thinking. Maybe Elizabeth Wilkins could answer that question later, but here's what I would say. When we started on this initiative, I spent a lot of time talking to people about how it was going to fuel the flames of those who are unhappy with dual jurisdiction in this area. There is a clearance agreement that describes which agency is going to review conduct and mergers in various industries. What does that mean for rulemaking? Does that mean that the FTC, because it's the only one with rulemaking authority, then reviews conduct in all industries? Clearance agreement be damned. And doesn't that...
Does the Justice Department have to enforce the FTC's rules?
Right, which I'm not sure it has authority to do. So I think this feeds the One Agency Act and gives more reasons to consolidate antitrust authority in the Department of Justice. As an FTC champion, I think that's a bad idea. But I think that's one of the significant downsides of competition rulemaking at the agency.
Dick Pierce?
Dick Pierce at George Washington University, and I raised my hand before you added your admonition, but I can't resist asking the question, recognizing that you may well decline to answer the question. But as I interpreted your op-ed in the Wall Street Journal, you were saying that the majority redacted portions of a dissenting opinion. I doubt very much that the majority has the power to do that, but even if they do, they certainly don't have the power to muzzle you. Do you plan to publish anywhere the redacted portions of the opinion, if I am interpreting your op-ed correctly?
I appreciate the question, and I also appreciate the blog post that you wrote, but I am going to decline to answer that question so that we can honor Aaron's vision for this event.
Jeff Lubbers? Yeah. Okay. Did you have your hand up over there, Blake? This is the professor corner over here. All right, yes.
Blake Emerson from UCLA. So I wanted to hear a little bit more about your theory that the question of whether FTC has rulemaking authority under unfair competition is a major question. I'm not aware of any cases where a court has held something like that. So I just wanted to know what your legal theory was there.
Sure. So if you look at the three prongs in the concurrence that Justice Gorsuch wrote, and I may not remember off the top of my head everything right now, but we had two law clerks take a look at this issue, this very specific issue, one of whom was actually studying abroad with Justice Gorsuch last summer, immediately after the decision came out. And they wrote analyses that indicated that this rule does hew very closely to the three prongs in his analysis. So first, is it going to have a major economic impact? Absolutely. The NPRM estimates that roughly 1/5 of employees in this country have non-competes. That is huge. That's a huge economic impact. Number two, political implications. Has there been legislation on this topic? Have there been proposed laws on this topic? Absolutely. In Congress and in all of the different states. whether we should have legislation banning certain types of non-competes or all non-competes. You've seen that popping up all over. And then third, is it going to somehow impede federalism and states' rights? Here, this NPRM would overturn 47 state laws. And so I think for every prong in Justice Gorsuch's concurrence, this does look like a major question.
Right. Yes.
Follow-up question. Why is it?
Can you introduce yourself first?
I apologize, yes. Orlando Economist, Sports Now. Why is it that you rely on Justice Gorsuch's concurrence as opposed to, say, the majority?
So it fleshes out the way the analysis might proceed.
All right. More questions? Anyone from this side of the room? All right.
No, so this side of the room is for professors, and this side of the room is for my current and former attorney advisors. Thanks, everybody, for coming.
All right. So a question I had for you, Commissioner, is similar. You talked about some types of rules that you think would be useful. I guess one I'd like to know is like how do you decide the categories that fall within good versus bad rulemaking? And putting aside like legal questions about what the agency's current authority is, if you were to ask Congress for like the optimal rulemaking authority, what would that look like?
To the multi-part questions before 10 a.m. on a Friday morning. Totally unfair, Aaron. So rules, how do you decide a good rule versus a bad rule? So I approach it with this notion that rules should be used primarily for market failures. And so if there is information asymmetry that a rule can help correct, that would be useful. Think about the funeral rule, where the FTC says you have to post the different fees for casket, et cetera, et cetera, et cetera, so that people aren't hindered by a lack of information during a very emotionally trying period of their lives. And I'll give you an example. After my father died, and this was in 1995, and I had worked as a law clerk for the FTC when I was in law school, and so I was familiar with the funeral rule. And my father died, and my mom and I went to the nursing home, and the guy was just awful. I mean, I think some funeral directors, not all, are right up there with used car salesmen. And he was going through his shtick, and I looked at him and said, "Sir, I have worked for the Federal Trade Commission. I know about the funeral rule. You're not living up to its obligations." And he immediately got very businesslike, pulled out a price list and said, "Okay, here's what you need to know." So information asymmetry is one area where I think it's important to perhaps have some rules to correct market failures. Number two, in the very specific circumstance of post-AMG being unable to get redress for victims, and we're talking about conduct that is clearly fraudulent. Like, I call you up, Aaron, and I say, "I'm with the Social Security Agency, and I have important news about your benefits. I just need you to verify that you are who you are by giving me your Social Security number." There is literally no rational, pro-competitive justification for that conduct, and in that instance, I'm comfortable with rules. And then what authorization should Congress give to the FTC for rulemaking? So the FTC actually does receive authorization to implement rules or to propose rules on the UDAP side relatively frequently. So for Graham Leach Bliley, Financial Services and Privacy, we were able to propose a rule. That's where, or for the Children's Online Privacy Protection Act. And the FTC says, Congress says, FTC do implementing rules. And when those requests are made with very narrow surgical topics so that they can be updated to take into account market evolution and adaptation and changing market dynamics, I think it works better than broad rulemaking initiated in the first instance by the FTC.
Okay. Question?
Sorry, Sorry, I just recovered from COVID. My name is Maarten Hoos, and I'm a lawyer from the Netherlands. I'm in the BYU International Law Program. And I was interested about point 4 of your notes, operate under the rule of authority granted by contracts. So yeah, I studied like European antitrust law growing up, and for me this is obvious. Like they, of course, they should operate within that, and I think it should be obvious to everybody here. But how do you see that happening? There should be like an extra administration for that in the FTC. How do you want to incorporate that? Make sure that they act within their granted authority, because it is so important that they do.
So I believe that it is incumbent on every political appointee who takes an oath of office to uphold the Constitution to monitor that issue for themselves. Internally, the Office of the General Counsel writes decisions on whether actions are consistent with our delegated authority. And I believe that the commissioners have an obligation to abide by those rulings by the Office of the General Counsel. I don't think we need different authority. I don't think we need to create a different body. I think ultimately the federal courts are going to hold the FTC accountable when it oversteps.
All right, any further questions? Going on. Oh, all right, that was almost. All right, there we are.
So looking forward a little bit, I'm wondering if you think that any pushback to the non-compete rule will hurt the FTC rulemaking appetite, or if you think it's just the beginning, we're going to see a lot more of this coming down the pipeline.
That also is a very good question to direct to Elizabeth Wilkins. Sorry, Elizabeth, I'm teeing you up for a lot.
All right, we
There's
have
one more.
right over there. Yes. Can you introduce yourself and speak up, please?
My name is Artie. I'm from BYU Law. Where do you feel the dynamics between empirical support or needs in the market conflicts with traditional FTC space and expertise? Like, if there is empirical support for problems in the market, that suggests that the FTC is meeting, like, there's an unmet need. So, if it is an area outside of FTC expertise, then a person's step needs to be taken as something like 15 comparison there. So how does the FTC evaluate empirical data and then contrast that with its own history?
Sure, so the question sort of distilled is, for those of you who didn't hear it, if there's emerging economic literature and empirical data on the impact of non-competes, and the FTC hasn't yet done anything and can't necessarily consider it to be within its expertise, then what do we do? It's sort of like you have to have experience to get a job, but you can't get a job until you have experience. Did I accurately characterize that? Everything, exactly. So here's what I love about the Federal Trade Commission. This is in its DNA. We have authority to do what are called 6B studies. We can obtain information under subpoena from industries, companies, and so we can really dig deep into different industries and look at what's going on sort of behind the curtain. We do workshops, we do roundtables, we do hearings. There are so many different ways that we can enhance our understanding and knowledge of trends in the marketplace. And we actually had, as Aaron mentioned, a workshop on non-competes 3 years ago. The Bureau of Economics did an extensive study of the literature on the impact of non-competes. As I said, it's a mixed bag. And so there are ways that we can take all of that information on board. The FTC is wonderful at doing that. And then I submit the rules that are proposed based on that foundation of experience should reflect the experience, and the learning that we have obtained.
All right, last question, thank you.
Neil Chilson, Stand Together, and wannabe Commissioner Wilson, attorney advisor, so I'm glad I said on this thing.
Except that Neil hates everything I say about consumer privacy and data security.
I actually have a question, though, on that issue. On the surveillance rulemaking that you mentioned is somewhat unique in that there is a long history of FTC action in this space. But unless I'm missing something, I don't think the rulemaking actually cites the 2012 privacy report that is sort of the foundation of the FTC's. Well, it's one of the touchstones for the FTC's best practices in this space. And I don't know what to make of that. I'm curious what you might make of it.
So let me just speak generally. You are correct. The FTC has immense experience in consumer privacy and data security. And for those who say the FTC has been lax and feckless in this area, let me remind you that we are working with a statute that is over 100 years old that talks about unfair, deceptive active practices. And Howard Beals and Tim Muris launched the Privacy and Data Security Program with Eli Lilly and Microsoft in 2001, 2002, and I think it's one of the crowning achievements of their careers. And so we have brought hundreds of cases since then. We have done dozens and dozens of hearings and workshops and roundtables since then. We have immense expertise with respect to a full array of consumer privacy and data security practices that we consider unfair or deceptive. The rule could have been carefully tailored to reflect that expertise. We could, in the absence of Congress being closer to federal privacy legislation, getting it across the finish line than it ever has been, we could have done a sound rule based on our experience that would have been a reasonable step forward. What we have now out for comment is very much untethered from our experience and authority. It wanders far afield of the cases that we have brought. And it is, it's asking for trouble. And it's caused trouble. I've heard from folks on the Hill that because of the commercial surveillance rule, there are many in Congress who had problems with the Three Corners bill that was introduced and who are now saying, oh, but the FTC is going to take care of it, so we don't need to worry about doing this, which is exactly what I was afraid of.
All right, and with that, we've come to a time. Thank you so much, Commissioner Wilson.